I'd like to welcome to the League of Women Voters Monterey County our speaker, Lisa Sparrow. She's the new president and CEO of the Monterey School of Law. She was the executive director of the Cal Poly Low Income Taxpayer Clinic for over a decade, and I read an online interview with a radio station there about the many ways they had helped people in their community. The Monterey School of Law is a nonprofit, community based law school with 4 campuses in California. Lisa graduated from UC Davis with honors and from the Oklahoma College of Law with as a top student. She clerked for the U.S. Court of Appeals and was a trial lawyer for the Department of Justice in Washington, D.C. for 5 years. In fact, I hear they're looking for lawyers there, so maybe she'll be back there. She taught a number of different law classes at Cal Poly San Luis Obispo. She also serves her community by actively volunteering as the judge pro tem for Superior Court and with the American Bar Association. She is definitely serving her community by talking with us today and giving her experience and expertise to the League. She's written articles on specific applications of due process, which is what we're looking at today. The League Board decided to devote a lunch and learn to due process as an area where we needed some kinds of education and guidance. Due process has been in the media recently as it applied to immigration discussions and deportations. I know we'll leave our meeting today knowing a lot more and having a clearer understanding about it and why it's important to us as Americans. So I thank you, Lisa, for agreeing to join us today.
All right. Thank you for that very kind introduction. And I'm excited to be here today. Yes, I am just not quite 2 months into my, my new role as president and CEO of Monterey College of Law. So thank you. I think you did introduce. I was just going to give a little background about the college. Their mission is to provide a high quality legal education in a community law school setting. Our graduates being dedicated to professional excellence, integrity, community service. This is a picture from the most recent graduation. I was a guest speaker there, even though I had not yet started my role. And I think I see at least one of our alumni on this call. So that's exciting. I don't know, there may be more as well. But for those of you who aren't as familiar, we are community based, founded in 1972. And by community based, it was a group of lawyers and judges who wanted to found a law school in the Monterey community to serve the Monterey community. And it's very unique in that the people coming to law school, traditionally non-traditional students, the classes are in the evening so people can work full time or care for families during the day. Since then, it has expanded. We now have campuses throughout the state. San Luis Obispo is the campus where I am located, so just a little south. And I know there's an argument between who's the Central Coast, is it Monterey or SLO? But there's also a campus in Bakersfield, Santa Rosa, and then there's an online hybrid option too, when we currently have over 250 students. So it's a very thriving law school. We have legal aid clinics that we offer in all of the communities in which we have campuses, everything from temporary restraining orders, family law clinics, and other services. So anyway, hopefully you're familiar with us. If
No,
you are
I,
inspired today, you might want to come to our law school. So that's a brief background on our campuses. And then I also want to kind of dive into why I'm here today.
Forward, trying
Let's
to forward
see.
it and send it.
I am hearing somebody speaking in the background, so I don't know if everybody could please make sure you are on mute. That would be great. Thank you. So, yes, when I was approached about speaking about due process, I was very excited because due process is actually something I have written on, I have lectured on quite a bit. And it is also one of those legal issues that's challenging because it is something that's subject to interpretation. It changes with new Supreme Court rulings. So I thought what I would do today is try to give a general overview, kind of get to the core concepts. I have spoken on due process to lawyers and to students. And so I tried to create this discussion somewhere in the middle because I figure some of you probably have a lot of background, some of you might not have any, but do feel free to ask questions if there's something that doesn't make sense. But basically, due process is this concept of fundamental fairness. And it comes from the Fifth and 14th Amendments of the United States Constitution. It's really meant to protect people from arbitrary and overreaching government. So the idea is we would have some type of substantive and procedural due process rights to keep our government from intruding too much into our personal lives or from taking things away from us without a fair hearing. I remember when I was in law school, due process really confused me when I first heard it. And I asked my law professor, well, what is due process? And she just looked at me and she said, well, it's the process to which we are all due. And I went, great. That did not clear anything up for me. I don't know if that helps you or not, but I'm going to try to do a little bit better job, I hope, of explaining it to you. I was the type of student that when something didn't make sense to me, I dug in deeper and tried to figure it out. So that's what I did here. So where does it actually come from in the Constitution? The first place is the Fifth Amendment. And so here we have the Fifth Amendment. There's a lot in the Fifth Amendment. And I know most people, when they hear the Fifth Amendment, if you watch a lot of movies or crime drama, people plead the Fifth. And that's in here, right? Nor shall a person be compelled in any criminal case to be a witness against himself. It also talks about double jeopardy is in here, eminent domain is in here. So lots of key things in the Fifth Amendment. I bolded the part that's due process, though, and that's the language that says, nor be deprived of life, liberty, or property without due process of law. And something that's important to see here. Oh, are you not seeing my presentation? I see a chat. Um, Are you not able to see my presentation? I practiced it with Dennis earlier and he was seeing it. If you're not seeing the presentation,
We're seeing it.
you are. Oh, okay. Oh,
Yeah,
good. I
we're
was
seeing
worried.
it. Yeah,
Okay.
we can see it.
Thanks for letting me know. I thought Dennis and I did a run through. I thought it was working. So some of the key takeaways here is I bolded the language any person because some parts of the Constitution only apply to citizens, but this is a part that actually says any person, which is important, especially in areas such as immigration. The other thing about the Fifth Amendment is it applies to the federal government. So when we're dealing with an executive agency, the president, something along those lines, we are dealing with the Fifth Amendment. Due process also shows up in the 14th Amendment to the Constitution in Section 1. And so this one, similar language you will see, but it says, nor shall any state deprive, again, any person of life, liberty, or property without due process of law. And you'll see just the clause right above it is the privileges and immunities clause. And that one specifically says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So you can see that distinction. And this is important when we talk about immigration cases. You do not need to be a citizen to have due process rights. Other than that, the language is fairly similar, right? Again, it says, any shall not deprive any person of life, liberty, or property without due process. It also, though, specifically says any state. So the way this has been applied is the 14th Amendment applies to state government actions. So this is just to let you know whether it is the federal government or a state government, you have constitutional due process rights, and they apply to citizens and non-citizens. Okay. So as we dive deeper, well, what does this really mean and what are these rights? So, what they have found is that there are two types of rights. One is substantive due process, and one is procedural due process. So, I'm going to talk about what substantive due process is first. And the Supreme Court precedent has held that there are some fundamental rights that are so deeply rooted in our United States history, traditions, that they are protected from government interference. Where this gets tricky is these are rights that are not spelled out, right? You hear about enumerated rights in the Constitution. These are rights that are not enumerated, they are not specifically spelled out. So this is left to the Supreme Court interpretation to let us know what those rights are. Judicial review is very important in the law, and that's why it matters who our judges are, who are making these interpretations. So, some of the key areas in substantive rights have been a lot of controversial decisions that you've that you'll read about, and they really go to the substance of the issue. So, some examples are the right to use contraceptives. So, the right to use birth control has been deemed a right under substantive due process. The right to marry people of a different race. This is the Loving decision. Now, if you were a group of lawyers, I would list the case sites and the information for each of these, but I thought I would just summarize the rights to you. So, this was an important decision. Interracial marriage came about through this. The right to marry someone of the same gender. So, gay marriage is a substantive right. The right to privacy, and this has included abortion rights have come under substantive due process, both the Roe decision and then the Dobbs decision that came out that overruled portions of Roe. Those were under substantive due process rights. The right to refuse medical treatment and end of life decisions. These have been brought under due process challenges. So you can see how important all of these are. An issue I want to raise, just because way back 30 years ago when I was in law school, I wrote my article. The law school where I attended, you had to write kind of the equivalent of a thesis, but it was a law review article. And I chose substantive due process looking at punitive damage awards. So you've probably heard of punitive damages. Sometimes these get headlines. These are the big case decisions where somebody gets hot coffee spilled on them and then they get $50 million and people say, is this egregious or not? Well, what has come into play is typically in a civil litigation case, you are compensating people for their injuries. You're not punishing them. But in some cases, people have found that these actions were so egregious that they warranted punishment. And that's where punitive damage awards come in. And my article was looking at, well, at some point, the courts have said the discrepancy between the actual injuries and the monetary awards is so vast that they violate your substantive due process rights. It's funny because at the time I wrote the article, my argument was the court needs to give us more guidance. That was over, well, almost 30 years ago. There's still not that much more guidance. So a lot of these areas, they are highly subject to judicial interpretation. What the judges see as fair, what they don't see as fair, what they consider a fundamental right, what is not a fundamental right. So these are just things to keep in mind as we go through. So then moving on to procedural due process, this sounds more like what it is. It's the process. So this has been a little bit more clearly differentiated in some ways. Typically, what they say is if the government is going to deprive a person of their life, their liberty, or their property, and right, you'll remember life, liberty, and property that comes right from the Fifth and 14th Amendment. Before they can do so, that person must be given notice, an opportunity to be heard, and a decision by a neutral decision maker. So it seems fairly straightforward. However, there's a lot of room for discretion here. So the first issue is what type of notice is sufficient? How much notice do they have to get? Do you know, is this a 30-day thing? Is this a 6-month thing? Is this a 24-hour notice? Again, it typically comes to fairness. What is considered fair under the specific circumstances? What is that opportunity to be heard? Are you actually entitled to a trial? Are you entitled to some type of administrative hearing? Are you just entitled to a government official hearing your case? How much time are you allotted? All of these things are discretionary. And then the third part is a decision by a neutral decision maker. So that's another question is, does this mean a trial? Does this mean a judge? Does this mean an administrative law judge, or could it be some other government official? So you can see how, there is a process. You have the right to notice, an opportunity to be heard, and a decision by a neutral decision maker. But the courts have found, depending on the nature of your interest at stake, is it your life, is it your liberty, or your property? What are the individual circumstances surrounding the case? What that notice, opportunity to be heard, and who your decision maker is can vary. So, what processes do? This procedural due process comes up quite frequently in criminal law. So this is why if you hear, if you watch a lot of criminal dramas again, you might hear, things get thrown out on a technicality or something. Often it could be a procedural due process violation. Maybe they were not given fair notice. They were not given the right to cross-examine witnesses. They were not given the right to an attorney if it was a felony case where their life or liberty was at stake. So all of this comes into play. So obviously, if your life is at stake, let's say you are on trial for murder and capital punishment is on the table, those are considered kind of the most extreme, where now you have the right to an attorney and you have the right to a fair trial, things along those lines. But it also can apply all the way down the line, because remember, this applies to any state or federal decision maker. So it could be situations such as a child going to a public school is going to be expelled. Before the school decides to expel them, they typically need to give notice. They need to give information about why they are considering this and a right to be heard. In a trial setting, it can come along the lines of you have the right to cross-examine witnesses. If somebody is providing evidence against you, you have the right to ask them and cross-examine them. Eminent domain cases. So this is another area where I have published papers on. This is something that was really interesting to me. I don't know if you all remember, a while ago there was a Kelo decision came out from the Supreme Court. It was a very controversial decision because eminent domain, right, exists in the Constitution. We just saw it. You saw it, and it is where the court or the government takes private property for public use. And the Constitution allows for this, but they do say you must be given the right, again, notice and the right for a hearing, and then just compensation. The Kelo case was interesting because the property was actually taken from private hands and given to another private entity. The argument was it was going to be redevelopment and it was going to be in the public interest and generate tax dollars, things along those lines. And it was very controversial at the time. That's what I wrote about. It's very interesting. Since then, most states have now changed the law to say, okay, we're not going to take private property and give it to private individuals. But that was a due process question. And then something that I want to talk about, because as Bev noted in the introduction, my most recent position was the executive director of a low-income taxpayer clinic. And what we did there was we represented low-income individuals who had controversies with the IRS. And what we would see there is a lot of people came to us when they had gotten a notice of intent to levy from the IRS. I sincerely hope none of you ever get one of these or ever sees one of these, but if you do, you should know you have the right to what is called a collection due process hearing. And that is something that we did a lot of in my practice. So if you ever get a notice, IRS thinks you owe them money, you typically have 30 days from the date of the notice. And this is very tricky because we did see some cases where maybe the notice is dated October 1st. The client didn't actually get the notice until October 15th, and they only have 30 days from the date of the notice to file their request. If you do file your request within that 30-day period, and it's actually pretty easy to do. It's a one-page request saying, yes, I want to invoke my due process rights to a hearing. Then the IRS freezes their levy action. And of course, a levy is where they're coming to take something from you. Usually, what we saw was money. They were going to come and take money out of someone's bank account, out of their paycheck, out of their Social Security payments. But a levy could be property as well. My clients were low income, so we mostly saw things like Social Security benefits, things along those lines. But it could be your house or something too in a different type of proceeding. But before they can do that, they have to send you this notice. The key is if you don't invoke your right to the hearing within those 30 days, they can proceed with the levy. So we always, when clients came to us, and I was running a student clinic, so I'd have to tell the students, okay, quick, what's the date? What's the time when we do not want to miss that 30 days? Once you invoke that right to a hearing, then the IRS freezes all collection activity against you until you have this hearing. And those hearings were done by an IRS appeals officer. And you would have the right to say either, look, I don't owe this money, or I can't pay this money, whatever your argument was. But you had the right to that hearing. And what we were seeing with the government backlog is often invoking the right to the hearing. You probably didn't get your hearing for 8, 9 months, maybe a year, but that gave you time to then prepare for the hearing and get ready. So that's just one example. But these are all procedures where the government has to let you know. But once you've gotten that notice, then it switches to you, typically, the person getting the notice, to invoke their right to be heard, to present the evidence they need, and then there's a decision maker. The question too with due process rights can be, what are your appeals rights? So once you have that hearing by this neutral decision maker, what if you don't like their ruling? Sometimes happened to me at the IRS. Then we had the right, in most cases, we could go to tax court then and have a tax court judge review it. Same type of thing can happen in other cases we've talked about, at the trial level. If you felt you didn't get a fair trial, you can then file an appeal and have an appellate court look at it. So these are the types of issues that come up with the procedural due process claims. So I was asked to talk about immigration cases, and I have to tell you all, I am not an immigration lawyer. I never practiced immigration law, so this is not my area of expertise. I did teach international business law, which touched on immigration issues. But I did some research for this presentation, so this is not legal advice here. But I thought I would hit on some of the key issues that we're seeing right now. And what this also is a good process and a good time to look at is the interplay of due process rights between our three branches of government. So when I was teaching law at Cal Poly, it's interesting to just kind of go back and think about how our system is supposed to work as far as checks and balances and separation of powers, because that's really coming into play right now with these cases. So, right, we have our three branches: the executive branch, which is the president and the agencies. And what we're seeing now is the president has been issuing multiple executive orders addressing immigration issues. And they have addressed legal representation, they have addressed enforcement activities, they have implemented different policies that we're seeing. So the president issues these executive orders or instructs the government agencies, such as ICE, is what we've been hearing a lot about, or the Department of Justice, and then they have to go out and enforce these orders, these executive orders, or defend them. So that's where a lot of these cases are coming up. And then, of course, there are the immigration laws that were passed by Congress. So we go to our second branch of government. And a lot of these laws have been around for a long time. One of the laws I'm going to talk about next is, from the 1700s. So there are more current laws, there are older laws, but it's how they are now suddenly being asked to be enforced by the executive branch and how the Supreme Court is interpreting them. which brings us to the third branch of government and the Supreme Court and the lower courts who actually do judicial review. So it's very interesting because I hope you've got a little flavor already. When you look at due process rights, these are things that are subject to judicial review, judicial interpretation, and how different courts look at them impacts their effect, their meaning, their enforcement. We also see through the executive branch which laws the president and the government agencies choose to enforce and how they interpret them. So there's lots going on here, and it's very interesting because when I was preparing for this, I was reading a constitutional lawyer's blog, and he was estimating that there are over at least 50 cases right now dealing with due process rights and immigration law at various stages in the courts throughout the country. So even, every day it's changing. One of the cases had a hearing just Monday. So it's very fascinating to see how this is playing out. We have an executive branch that's being very aggressive with its enforcement of immigration laws. And then we have a lot of nonprofit groups. We have a lot of states and other organizations that are pushing back and bringing these judicial challenges that are working their way through the courts. And what we're often seeing is there might be one ruling in one part of the country at a district court level, and then it goes up on appeals, and there might be a different level. And then in another jurisdiction, we might have a completely different ruling, similar issues. So I don't know, I'm not trying to be confusing, but I just want to say I don't have all the answers. We don't have all the answers even yet for what the courts will find. And what we're seeing a lot of are preliminary rulings at the district level that are then being appealed. And some of the appellate judges then will issue a stay or an injunction. And so, in legal terminology, if they, and especially things like an immigration case, if they go ahead and deport a person while their case is pending, making its way through the court system, which can take a while, the argue is there's irreparable harm because the person's already been sent out of the country. They've lost their job. They've been separated from their family. Whatever things they were trying to escape from the other country have come to pass. So typically, while a case is pending, they will ask for a stay or an injunction preventing actions from happening, such as deporting or enforcing laws. And these are a lot of the cases we're seeing now because a court will grant a stay or an injunction, and then that gets appealed. And some of those have gone up to the Supreme Court and been reversed. What's important to note is most of those cases are just looking at whether the stay or the injunction was valid. It does not go to whether the original actions are valid or not. That is still working its way through the court. So anyway, if I give this discussion again in a year or two, we might have more answers. As of yet, there have been no oral arguments scheduled for any of the Supreme Court cases dealing with immigration. There have been some, they call it the shadow docket, which are basically these just very short decisions, and they're dealing with very specific issues, such as should this stay be allowed or not. But they haven't really gotten into the deeper issues. So I wanted to give just a brief overview of some of the laws that are coming into play and that we're hearing about a lot right now. The basic immigration law, the most fundamental one, is the Immigration and Nationality Act from 1952. And this has been the primary law governing immigration policies for the United States. It's the one that provides the framework that the typical procedure would go through about who may enter. It sets up quotas, things like that, how many people from which country. It also gives preferences. Our current system has given preferences for family members of citizens. So you have citizen family members who are seeking to sponsor, bring over from another country members of their own family. It also has allowed for skilled workers, skills that we need here as well. So there have been many updates of this over the years. I'm not listing them, but this has been the traditional framework in immigration cases. And people would apply for a visa, and then they would go through an immigration court process where typically they would have a lawyer representing them, and they would be able to present evidence and go through it. I have a good friend who's actually a graduate of the SLO College of Law, Monterey campus, and she's an immigration lawyer, and she would come and lecture in my class at Cal Poly. And she had some harrowing stories because even under this system, things were not working out very well. Oftentimes, there were substantial delays, a lot of cost involved. It was not an easy process to get people in the country. But this is kind of the basic law. A law I wanted to bring up, this is the 1700 law that I referenced earlier, because this was in the news quite a bit, and this was the Alien Enemies Act. And just a note on wording, the Constitution and a lot of the congressional laws use the word alien. It's a disfavored term to use for people from other countries, but it is the word that shows up in our laws and in the Constitution, so you will see it referenced, although it's not the one that people prefer to use today. But this act provides that during a war, invasion, or predatory incursion perpetrated or threatened by any foreign nation or government, the president may issue regulations directing the conduct of or otherwise restraining citizens or nationals of the hostile nation or government. So this was really meant to be an emergency war powers type of act to give the president the authority if we have hostile nationals in our country to treat them differently. It would be considered kind of a waiver of their due process rights. And this had only been enacted very rarely before. I think it's around three times in the past, and it was typically when we were at war. So it was invoked this year in March through an executive order against Venezuelan people living in the United States. And the justification was that the Tren de Aragua gang was considered an invading force that the United States was at war with. And so the idea was, because we were at war with this group that was perpetrating or threatening violence against us, that the president could restrain, and actually they deported several hundred Venezuelans, many of whom disputed, said, we have nothing to do with this gang. Um, and so that has been pending throughout the country. There are several cases here. The Supreme Court did issue one of those very short decisions here, saying that they were entitled to some type of hearing before they left. However, what that hearing is still being disputed. It's not a court hearing, and it was also deemed that this one decision, it would be in Texas where it was happening. So this is something that's still working its way through, but you might have seen in the news. Another one, and this has been a very controversial, very heavily litigated area, is the Illegal Immigration Reform Responsibility Act. And this is from 1996. This was a Bill Clinton helped bring this in to try to expedite removal of non-US citizens and people attempting to immigrate to our country. The idea originally was these were things being done at border crossings, was the initial idea, and it was allowing for expedited removal. And this expedited removal is something that's been in the news a lot. There are a lot of lawsuits pending currently regarding it. If any of you are This American Life fans, there was recently a podcast they did on this expedited removal that I thought was interesting, and it's an hour long. So if you want to hear more, as opposed to but I'm trying to fit it in my 30 minutes today. But this looks at if somebody's made material misrepresentations, fraud, or false claims of US citizenship, or they have failed to provide valid entry documentation. So one of these two things, and it's when they're arriving in the US, So this would be the idea, at a border crossing type of idea, or they've been continuously present in the US for less than 2 years. So where this comes into play is it's to try to speed things up. You don't have a full trial, you don't go through the visa process, you don't have an immigration judge, but instead there's a customs official who listens, asks some questions about where are you from, where's your documentation, how long have you been here, and then they have the discretion to just remove people instantly without the trial. So this has been very controversial. There are some exceptions. One exception is for asylum seekers, because this has been part of our immigration policy of our country for a long time. The idea that if you are fleeing persecution, torture, other types of violence, perhaps due to your religious beliefs, your gender, your sexual orientation, things like that, that you would be given shelter in the United States. So there is an exception if you say during this interview that you are an asylum seeker and asylum and that you are fearing persecution or torture if you are returned to the country from which you're coming. The customs official then meets to determine if they believe you have a credible fear of persecution or torture. If they do deem you have a credible fear, then you can be taken out of this expedited removal and put into the regular process where you'll have a chance to be heard and present evidence before an immigration judge. If they don't think you have a credible fear, then they can remove you. There is an option for you can ask a supervisor to look at it again. And if they think you have a credible fear, they can move you forward. If they don't, then you do have a right, I think it's only about 24 hours though, to go before an immigration judge. So you can see when you're thinking about due process, what's happening here, right? A lot of people are saying you're not being given that fair process, the procedural ability to be heard, because these things are happening very quickly. And so you may not have time to gather the documentation you need. You may not have the documentation with you. You may not have time to have a lawyer be there to represent you. So these are all issues that come up, and these are some of the due process claims that are being made in these types of situations. So I just wanted to highlight just a couple lawsuits. There are many. This Make the Road New York versus Nome. This is particularly looking at the expedited removal as a due process violation. There was a lower court ruling that did find it to be a violation. Appellate court arguments were just heard on Monday. So last time I checked, a ruling had not come out. I don't know if if today or soon one will come out. But these are issues where they are saying this is a due process violation, that people should have the right to be heard. They should have the right to prepare and present evidence, and this expedited process is violating those rights. So it'll be interesting to see how that proceeds. Nome versus Vasquez Perdomo. This was happening in Los Angeles. If you followed that case, there was this concern about immigration officials basically being able to stop people and detain them just on the streets. And if they have a belief, a reasonable suspicion based on the totality of the circumstances that they are in the United States illegally. If they are stopped by ICE or other government officials, the person then must prove their legal status. And so there's a ruling just in September that the Supreme Court stayed a lower court order that had paused enforcement. So a lower court had basically said they had to stop this process because it had the potential to have due process violations. So they needed to wait till the lawsuit went through, and then the Supreme Court overruled the pausing of that. So there have been a lot of lawsuits along this and other similar procedures, because the concern with some is that there's racial profiling going on, where they're saying they're going to people who look like they're from another country, who maybe English is not their first language, who have they have particular jobs that are associated with immigrants. And so it'll be interesting to see how this plays out. So there are lots of cases, as I said, over 50 plus working their way through. Some are challenging particular laws, some are challenging particular executive orders, some are challenging how the laws are being enforced and applied, and some are just dealing with specific individual cases that are happening. So I know it's a very big overview. I think I'm about at the, I was told to speak for about 30 minutes, and I think that's about where I am. But I hope you have a better understanding of what due process means in this setting, how it's interplaying. And a lot of it for right now is we are watching how the courts are going to what they're going to come forward with, what these rulings are going to be when we actually have oral arguments and thoroughly written decisions. So with that, I'm happy to take any questions. I don't know, Dennis, if there are any questions that
What I'd like to do, since this, we thought water issues were complex, this is even more complex than that. If you would put your name into chat, and then I'll just call you in the order that the names appear, and we'll be starting off with Susie Worcester. But I'll just call you, and you can then unmute and then ask your question directly. So if you have questions, just put your name into chat, and I will call you in that order rather than looking for your upraised hand. And I am also going to make myself the host again. So
okay.
Susie, why don't you go ahead?
My question is, I think this, can you hear me?
Yes.
Yes, I
Good.
can hear you.
Okay, I think it's that last one, Vasquez Perdomo, is the one where you could be taken just because of who you look like. And like, so how does this relate to the Civil Rights Act and other acts that have been passed? Because it seems like a complete about face. And so I'm under it's the three branches, I think, questions. I'm not sure it's the best one, but can you talk about how
Yeah.
this could be possible?
And that's a good question. And not all of the immigration cases are being brought as due process violations. So you're right, there is an interplay, things like the Equal Protection Clause, the Privilege and Immunities Clause, things like that also are being challenged. For this talk, I just tried to zero in on due process, but you're absolutely right. There are other laws that also come into play here. So the Civil Rights Act primarily applies to things like public accommodations and things along those lines. Things like you know being discriminated against in a like they can't not serve you a meal or let you have a job or work somewhere. And there a lot of these there are balancing tests that are going on, and that's another area where discretion comes into play as far as if somebody and if there's safety concerns, then sometimes some of those due process and civil rights can be waived. And that's an argument the government is making that it's a safety concern, which can waive other claims as well. Yeah, but you're right. It's a good point to make that it's not just due process concerns that are being raised. There are civil rights violations, privilege and immunity, all sorts of other constitutional rights and rights afforded through other laws also are being challenged in these cases. Yes.
Thank you. Next, we have Mickey Welsh.
Oh, hello, Mickey. Nice to
Hi.
see you here.
Thank you. Thank you so much for being here. This is very informative, Lisa. I mean, President Sparrow. And my only question was, what are your thoughts on whether or not this court, when it actually hears cases, is likely to redefine due process in a way we have not seen before?
That's a really good question. Because so far, this court has, for the most part, been very friendly towards the Trump administration's policies. That the ruling that I listed here with the make the road, yeah, let me see. There have been several. This Venezuelan case was very interesting because they actually did reaffirm the right to a hearing, which was good. They did say these people should be getting a hearing. So it hasn't been a complete change, but the way that the court has been ruling on the majority of these injunctions and orders for stays has indicated that they are willing to let these actions continue. So I would not be surprised if we do see some changes in the precedent coming from the Supreme Court in due process issues. It will depend which cases they choose to hear. I think how extensive those changes are and what happens there. But it is a very good point because judicial review, it changes with who the current judges are. And as we saw from the Roe decision to the Dobbs decision, having a different Supreme Court look at the same Constitution, they can come up with different interpretations about what is a fair process and what is not. So yeah. I would not be surprised given what we've seen if we don't see some changes, maybe some narrowing of what's previously been considered appropriate. Yeah.
Let's see, are there any other questions? I noticed that we have a number of our members who are attorneys on this
Oh, good. I
meeting.
wasn't sure how many attorneys we would have, so it's good. And
We
I'd be
have
interested to hear if anybody does immigration law too. There might be some people who've been more involved in these cases than I have been. I do know it's a hard time to be an immigration lawyer. My friend who is an immigration lawyer she actually took immigration law off of her shingle because she has a newborn baby and she has a private practice and she was getting death threats and things. And so anyway, that's something. Maybe be kind to the immigration lawyers right now. Oh, George Riley, looks like you have a question.
Yes. Go unmute yourself, George.
Got it. Unmuted. I'm curious about when the Supreme Court makes a decision, how soon is it become effective, and how does that work? I mean, do people just get it from the news?
Yeah, and go ahead. That's a good question. I know when I would lecture for my students, I would say the Supreme Court are just 9 judges in robes, right? They don't actually have an army to go out and enforce, but the executive branch is the one that enforces the laws. So if in this case, President Trump has issued a number of executive orders, and the agencies, if they get a decision, basically codifying what they're doing and giving them the go ahead, I would think they would be pretty quick to go out and work with the Supreme Court's approval. If it's the opposite way, if the Supreme Court says no, there are some questions then. You've heard talk of a constitutional crisis and things like that about would the agencies they are supposed to enforce and follow what the Supreme Court says. So if the Supreme Court says, no, you must be giving these people 30 days notice, not on the street notice, you must be giving them the option to have a trial. How would that be effective? How long would it take for that to go into play? And that is up to the government agencies that are doing so. Ideally, hopefully, usually Supreme Court rulings go into effect pretty quickly, unless it's something that requires a change in the law, and then it might go to Congress to actually change the law. So very complicated question. I guess it depends. If it's the Supreme Court saying, yes, what you're doing is fine, you're not violating, then that's pretty quick. If it's something though that would change process or change how current laws are being applied, then that would be could be much longer.
Could I just
you.
pursue that question just one more? The recent decision, the shadow docket that said you could continue to I say entrap, that's the wrong word, I know, but the on site, on just physical appearance. And yet that's kind of contrary to our existing law. They allow it to continue until what? It gets heard more in an official way later?
Yes. Yeah, so there it is working its way through the court system until there's been a full trial on the merits. When you file for a temporary restraining order type of situation or an injunction or a stay, you're just saying there's a likelihood we could prevail on the merits, and if we do, irreparable harm will have happened if you haven't stopped this procedure. So that's what's been heard now. It hasn't had the full discussion looking at the merits, looking at the law, looking at the precedent for most of these cases. And then when some of those cases have been heard at the trial level, they immediately get appealed. And so then there's an appeal pending, and the appeal could find differently. And then there could be a third appeal up to the Supreme Court. So even to the extent some of the trials have been ruled one way, if there's an appeal pending, that can throw further questions. So yeah, I mean that's a good issue, is why and sometimes that's why Mickey's question of, how might the court rule? Well, generally, if a court's inclined to find an action invalid, then they will allow the stay or the injunction to continue. And if they're not, so that's, some people see that as a precursor to what's to come.
Yeah, thank you.
Okay, thank you, George. Let's see. I don't see any more questions. I do, among all the attorneys who are, Marianne Gawain.
Sorry, just taking me a little time to formulate the question. But I mean, I'm sure you're going to say it depends. But if you could comment a little bit on how extensive and particular the requirements can be for example, say someone has to have notice in a hearing. How much does the court comment on, like, is the notice comprehensible? Does the notice have to be in their language? They presumably, it's not like a criminal proceeding, so they wouldn't get legal representation, but does there have to be some mechanism where information is presented to them about what will happen and what the expectations, that kind of thing? How much of a burden?
Yeah, no, and that's a really good question. And that is an issue that's very much at stake here, because you're right, particularly if it is an immigrant, maybe English is not their first language. Maybe they don't speak English. And if the notice is only being provided in English, then that is in fact fair notice or not. And as you said, it does depend. It depends on what the court is going to say. And many people would argue, it needs to be fair notice that they can understand, and that they need to be given time to respond to. Whether the courts will agree with that or not is an open question. But you're right, that does. And I know even at the IRS, we were arguing that all of the time, because we would have clients come to us who didn't read English, and the only notices they'd ever gotten were in English, despite the fact that they had let the IRS know by filing a tax return in a different language. And there was some headway being made with that, although now I think that's being changed, and they're going back to English only language. So it will, we'll have to see how the courts rule on that. So I did put up my last slide. So I hear there are some lawyers there. If any of you are now inspired to go to law school, you could come and join us. I also, even though I'm based in San Luis Obispo, I am coming to Monterey quite frequently, and I'm trying very much to get to know the Monterey legal community. So I'd love it if any of you want to discuss this or other issues, to reach out. Love to get to know some of you and learn more about the issues with your organization and things. So please feel free to reach out to me.
Thank you very much. And I think some of our attorneys who are on this meeting, let's see, I noticed Joanne Kelly and Mickey and Catherine Stoner and Fran Gaver, they may be applying for continuing education credits there. Let's see, Marianne Gawain, can you
No,
make
No, I was just very proud of myself doing the clapping reaction.
Oh, okay.
I really enjoyed it.
Well,
Oh,
thank you. It's always hard doing these via Zoom to know the circle, but thank you very much. I really appreciate the opportunity to come and speak with you all about this. It's a very important issue. And as the lawyers know, it does depend. And this one in particular, it is being so heavily litigated all over the country at so many different levels that it's when I was preparing, I kept thinking, you don't know what's going to happen. Is there going to be another ruling? While I'm speaking, there could be another ruling. So anyway.
So, Mary Ann, did you want to make any comment about November's Lunch and Learn meeting?
Yes, it's I think relevant to people who are interested in what we're talking about here. We will be having we hope to have a panel. We have secured as a speaker our superintendent of schools, Deneen Gus, who will talk about immigration policy and enforcement actions and how the impact that's having on our school communities. And we have not finalized our speaker, but we're reaching out and hoping that someone from the agricultural industry will be also commenting on impact on the workforce there. And that will be an in-person meeting.
Okay, thank you very much. And let's see if there are no last minute
Dennis, one more
announcements
for
from
George.
league members. George Riley.
Well, I just want to say in January, the program will be on renters' rights and complications with that. So that'll be the league's Lunch and Learn in January in person at the UU Church.
Okay, thank you very much, George. Okay, so a very meaty meeting this month. Thank you very much again, President Spurrow. And we will see everybody in person on November the 3rd. And this concludes our meeting today.